Okay, perfect. Well, I'm so excited and honored to be here discussing this paper. It's a really great forum. I've attended a couple of these talks. We've gotten some wonderful speakers together, and I'm honored to be among their number. And actually, I should be back in Berlin this summer, so hopefully I'll be able to meet some of you in person if there are talks to be had in May and June. The paper I'm going to talk about today is private rights of action in privacy law. This is a particularly American issue in a lot of ways because private rights of action play an important role in regulation, not just of privacy, but regulation in general in the United States. And I'll say a bit more as to why as I talk through the actual points in the paper. But I do think it's of interest to a European audience because there has been increasing use of private rights of action in European legislation, regulation as well in recent years. And there's been, of course, a lot of thought about whether or not that's a good thing and also tailoring it, right? Because you guys don't necessarily want to have the sort of system we do with a huge amount of reliance on private rights of action. But it's trying to evaluate the particular virtues of this form of accountability, form of regulation, and seeing where it can be a fit. And I think one of the areas where there's a fairly strong case for a private right of action of some scope is privacy law. And I think that's true both in Europe and the United States. I think, as you'll see by the nature of my argument, the argument for private rights of action and privacy law is stronger in the United States, as belief, just because of how we regulate in general. It's unlikely that pure public regulation will do the job based on the types of systems that we have in place in the regulatory background. But no matter what type of regulatory system a country has at this point, given the nature of the right to privacy and the landscape, the techno-social landscape in which individuals are interacting, a private right of action is particularly important. But I will say more as to why that is later. So I hope a lot of this talk will appear to be very much talking to an American audience, but I think that weighing a private right of action is something that's of interest to a European audience in general at a more broad level, because justifying private rights of action in general is not actually that controversial in the United States. But the bigger question of should private rights of action be used is bubbling up in Europe. So I hope this is useful from that point of view to you as well. The basic idea here is, the reason why I wrote this article is privacy legislation seems to be coming on the federal level, and it's certainly coming on the state level. Every year, another state, at least one state, passes Omnibus privacy legislation, which is to say legislation that covers sort of all industries, all types of people, to generally regulate privacy, in contrast to the approach that was taken by states and federal government before, which was sectoral. So at the time that we're talking now, Colorado and Virginia, and most famously California, all have omnibus privacy bills. Utah just passed one, so it should be signed into law, or possibly could be signed into law soon, so we could be up to 4. And many states have active privacy bills, including Florida, actually. So there's been a consensus, effectively, around this. There's been a growing consensus around this idea that privacy regulation is necessary in the United States, because in the United States, there was There's been, and this has been chronicled in a really interesting article that I like to cite for this idea called The New Privacy Law by Ari Waldman, which sort of historically chronicles in the United States a transition from a sort of laissez-faire, who needs privacy regulation attitude, where there was a thought that just giving people notice of privacy practices and allowing them to consent will be enough. Lots of references to the idea of a privacy paradox, which says regardless of what people say they prefer, if people choose to share their information with any company for any reason, that shows they secretly don't care about what they claim to care about. So these are arguments that had real currency in the United States before roughly around 2010. And since 2010, there's been a trend away from that, growing kind of overwhelming societal sentiment that some type of regulation is necessary. And there's been a sort of stepping back of industry, because you're seeing in states of different types, you see Utah is a red state, Colorado and Virginia are sort of purple states, California is a hard blue state. So kind of across the spectrum, we're seeing the political spectrum in the United States, you're seeing a concern about privacy from citizens and their representatives. So tech, in their ever adaptability, have kind of shed the idea that nobody cares about privacy. Privacy regulation is unnecessary. And now they're at the table trying to shape what privacy legislation is. So kind of loss minimization strategy, right? I think maybe perhaps in an ideal world, they prefer no regulation at all, but they now see that as unrealistic based on how legislators are behaving. So given that legislators in states have their druthers to actually pass legislation, it's better to be at the table saying what the legislation is, as opposed to not participating and having the legislation potentially be even worse for them. So saying that regulation is necessary and proper in the area of privacy now puts the United States in step with the global zeitgeist. So we're talking many jurisdictions have passed comprehensive privacy legislation. The European Union has been ahead of the curve on that, but more recently, countries like China, India is coming out with one this year. It's becoming kind of standard practice. So another reasons besides global sentiment and national sentiment, even in the United States, that industry in the United States is so interested in federal privacy legislation is that we're hoping for some type of simplification. In the absence of any action by the federal legislature in the United States, individual states in the United States are coming up with their own approaches. Countries all over the world are kind of, the GDPR is pretty influential, but outside of that, there's all types of regimes that different countries are coming up from. And the hope with federal privacy legislation from industry is that it will at least make things more uniform. So they would have less things to comply with. So the intervention of this paper comes from the idea that, so first of all, there's actually, this paper contributes to an active discussion on the state level about what ground a privacy law should cover, either at the federal level or the state level. So what's interesting about privacy laws is there's a great deal of consensus, or I would say lack of controversy, around the ground a federal privacy law or state privacy law should cover. So what's interesting is companies are actually amenable, companies and people and legislatures who are giving an ear to industry concerns They're actually now, I mean, as we've seen chronicled by Waldman and that paper and the like, companies are actually amenable now to an understanding that citizens care about privacy, citizens have a right to privacy, and that notice and choice, purely saying this is our privacy policy and having people consent to it, is insufficient to delineate privacy rights in an interconnected world. They've even shown some support for the idea of fiduciary duties existing between firms and consumers with respect to personal information. So it seems like in terms of substantively defining privacy, everything is kind of on the table. The two principal fault lines are holding up legislative action on the federal level. Preemption and private right of action. So preemption is only relevant to federal law in the United States, and that effectively says that if federal privacy law it preempts state laws, that means in the United States the privacy legislation, the privacy rules will be determined only by that federal law, and all the state privacy laws will only be effective insofar as they don't contradict the federal law. And of course, industry wants federal law to preempt state law because it will limit how far state laws can go to protect privacy. That's the sort of bad actor, not bad faith, but that's the sort of more bad faith interpretation. A little bit more of a sympathetic interpretation is that even with the four different privacy bills that we have that have passed right now in the United States, even though they could be covering, they are covering in a lot of senses similar terrain, like right to delete, right to explanation, things like that. The exact way that Colorado defines the right to portability as between, let's say, two different services by the same company would be different than how California does, for example. So you have to make sure your language and your program is compliant with as many different jurisdictions that they are. And even if the legislation has the same goals, the exact way that you implement it, to be sure, could be different. So having many different systems, and the more different systems you have, the more expensive it is to implement, even if the legislation doesn't actually have different goals or different goals per se. So even if both laws are equally quote unquote strong or give accord effectively the same right, they most likely are phrased slightly different, and you have to comply with exactly the law as it is in each state. So the more sympathetic interpretation of companies wanting preemption is actually this idea that a more to sort of spare them the expense of having to deal with all these regimes. So that's the idea of preemption has been talked about quite a lot in the idea of federal privacy regulation. But by contrast, there's scant discussion of weighing the value of a private right of action in privacy regulation, either at the state level or the federal level. So private rights of action, what are they? What do I mean when I say that? They're the ability for individuals to bring a case in court or another forum against another. So statutes create any number of rights for individuals, or let's say bar certain companies from engaging in certain types of conduct. However, when a right isn't accorded, or when a company acts in a way that is in contrast with what a piece of legislation says, who is able to go in and vindicate that right or contest that practice? The answer when there's a private right of action is that any citizen who gets a lawyer who has the ability to do so, of course, that's a big question of access to justice, we'll bracket that for now, can bring this case in court. So I argue that private rights of action are very important to include in privacy legislation. And I'll say more later about what in particular type of how wide the scope of the private right of action needs to be to achieve the sort of goals I'm talking about. But broadly, that when you're thinking about what type of legislation you might want, let's say you're a privacy advocate, would you rather have a broader set of claims for private privacy rights, so say define the privacy interest more expansively, or would you rather have the privacy interest defined more narrowly and have a private right of action be available? Is it worth trading off, let's say, substantive protections for privacy in exchange, if let's say there's going to be some type of a trade-off for the availability of a private right of action? So I say yes. I say it's definitely worth it to include a private right of action, even if it means compromising in terms of the scope of that private right of action. So I'm fine with limited private right of actions, which means that, let's say, consumers can't sue under every single feature of a piece of legislation, or consumers are limited to cases and controversies they're limited to in their relief to a certain dollar amount, or that they can only bring claims against companies of certain sizes. I'm okay with limiting the private right of action in some ways, but there definitely should be a private right of action in any proposed piece of privacy legislation. Why is that? So I've kind of two types of arguments in favor of this. So there's a weaker version of the thesis and a stronger version of the thesis. I'll start with the weaker one, and that's the first argument that I'm going to make. By weaker, I mean it's more conditional. It's a little bit more focused on the system that we have in the United States. But the stronger version holds true no matter where we are. So one argument in favor of a private right of action is, in fact, it has important benefits for privacy regulation. It makes privacy regulation more effective because it deters and provides it deters bad acting by multiplying the number of enforcers. So this basically means that having a private right of action allows individuals and private attorneys general to come in and vindicate rights. And the good feature of this is a company who wants to avoid getting in legal trouble under a purely public enforcement regime. All they have to do is convince the enforcer or enforcers that they shouldn't take enforcement action. Whereas in a hybrid enforcement regime, so basically, I call hybrid enforcement a regime where there is both public enforcement, which is to say regulation of these privacy rules by public actors, agencies, and private enforcement, which is regulation by private citizens and their lawyers. When both is present, I call that hybrid enforcement. So I make the argument that private enforcement is necessary for private regulation in the United States. We need both private and public enforcers because having private enforcers support the public enforcers leads to more deterrence, more thorough regulation. So what role, and that's the sort of weaker argument. Basically, there's the argument from deterrence and more effectiveness pragmatically. And the stronger version of this argument is private rights of action have legal meaning and instrumental and benefits that can't be achieved through public regulation. So this is kind of the dignitary argument here. So basically, when we talk about privacy rights, we're talking about personal dignity, rights personal to an individual. Not allowing the individual to vindicate those rights herself is sort of an inappropriate structure. especially when the dignitary aspect of why we enforce privacy is really strong, it seems particularly wrongful to not allow the victim of privacy enforcement to be a participant in enforcement, especially given the reality that the public enforcer isn't necessarily going to be able to enforce every single instance. So there's the argument from deterrence, which is sort of based on realities about how enforcement actually tends to work. And then there's the argument from sort of personal dignity, which says that, if we really take privacy rights seriously in terms of what they are and the importance of the role of dignity, we have to accord individuals the right to vindicate these rights, even if public actors refuse to do so. So what I'm going to do from here on out is talk about those two arguments for private rights of action, the argument from deterrence and the argument from dignity. And then I'm going to, the paper actually talks about a couple of examples of privacy problems. And I basically say, by looking at these privacy problems, we can see how important private rights of action can be. So the examples I talk about in the paper are non-consensual pornography, data insecurity, data power, digital market manipulation, and government surveillance. But in the interest of time, I'm only going to talk about non-consensual pornography and data insecurity in this case. And these two particular privacy problems illustrate how these two ways of justifying private rights of action, how they work in the context of addressing particular privacy problems that are kind of different types. Because as we know, the privacy interest covers many different types of situations. So let's start by comparing private and public enforcement of privacy law to the hybrid enforcement of privacy law, which this paper advocates, which is to say having both a private right of action and public enforcement. So in this paper, I'm not arguing that private enforcement, which is to enforcement by individuals and private rights of action, is a substitute for public regulations. What I say is that it plays a supportive role, which adds additional deterrence and enables individuals to vindicate their rights. So this is a supportive role. So private rights of action. I'm going to start with this sort of deterrence argument. Play an incredibly important role in American legislation. They are the major way regulation gets done in the United States. Since the mid-20th century, there's actually been increasing reliance on private rights of action to achieve regulatory goals. So Sean Farhang, a professor at Berkeley, has quipped that in lieu of a European regulatory state, the American system has a litigation state. And enthusiasm for private rights of action crosses ideological lines, with conservative and liberal legislators alike seeking to use private enforcement to shore up rights they consider important. And so as a matter of practice, regulation, when we deny private rights of action in the United States, enforcement tends to be incomplete because due to economic limitations of agencies, they don't have unlimited resources to pursue every particular action. Limited and atrophying expertise by agencies, and changing executive will. So administrative agencies are under the aegis of the executive. And if the executive doesn't really agree with the goals of a given agency, they're not going to provide funding, they're not going to provide good staff. So public enforcement is effectively limited by the capacity of these agencies, the ability for them to avoid capture by industry, and ongoing sympathy by the executive to the goals of those particular regulatory goals. And that's why public enforcement on any given topic can ebb and flow. It can be more or less. And we see, and to underscore it as well, to the normalcy of private rights of action in American regulation, we actually see it in a lot of areas, a lot of important areas that kind of have a lot in common with the areas that we're looking at, right, which is privacy. So, for example, securities, legislation, employment, and many areas where there's both a combination of being very important to the potential victims and a huge amount of complexity, and a large number of cases, right? So we see a private right of action in employment, in securities, in consumer laws, in antitrust, because the government can't be everywhere. These are important government interests that maybe people in the private sector might know more about than people in the public sector. So we accord this private right of action so we can more effectively blanket regulation to make effective protection available to all affected people. And so this is a prominent tool. Civil rights is another area as well. It's kind of related to employment. Employment is a common, but hybrid enforcement regimes exist in antitrust, securities, civil rights, and consumer protection, among others. The public enforcement system in the United States is reliant for its effectiveness upon private enforcement systems in many areas of complex regulation. And so absent a rehaul of the public administrative systems that we have in the United States, relying on public enforcement alone is unlikely to be as effective as a hybrid regime. So this is an argument from effectiveness based on what we see in other areas. So in the article, I make this general. So I start by making this general point by this is a widely used area. This is a widely used regulatory strategy in the United States, and it's been used with success in these areas. The employment law. There's actually been a lot of sort of documentation about how the EEOC and other forms of employment law actually do offer a significant deterrence to discrimination and unfair practices in the workforce, because there's no need to get the attention of a regulator. Every single individual can potentially start an EEOC claim. So what I do, so it's easy to refer to hybrid regimes being successful in other areas of law and say, well, we have privacy has similar characteristics, so perhaps private rights of action should be present here too. But what I do to underscore this point is I in the paper talk a bit about how there's regimes in privacy where there is only public enforcement, regimes where there's only private enforcement, and then there are regimes that are hybrid in the way I described, where both an agency and private individuals can bring claims and can enforce the law. And as it turns out, the most successful regimes have been hybrid enforcement regimes. So an example of privacy regulations that are purely publicly enforced are the Health Insurance Portability and Accountability Act, which is HIPAA. This is something that governs health data. There's the Children's Online Privacy Protection Act, which is COPPA. This regulates privacy protections for children under 13 in the United States. And both of these areas of practice have been critiqued, but for simply not proving expansive or resilient enough to create accountability. Websites have been able to avoid the COPPA privacy regulations entirely by simply requiring each user to claim they're over 13 without confirming the validity of the user's purported age. And since that's a pretty, this is difficult because you don't actually have the availability of private right of action where it's sort of a group of people who are under 13 and you can know who they are and say they were harmed by using an app. That would be an option, but this verification, but simply by saying, oh, I didn't know they were under 13, they've been kind of able to get out of that. So while the FTC also is an example of public regulation in the area of unfair and deceptive practices, they can only they say they're a norm entrepreneur, right? So HIPAA and COPPA have been they've really struggled to make any type of a difference. The most flattering example of public enforcement, purely public enforcement, is probably the FTC's unfairness and deceptiveness role. And they have helped out with this. They've been a primary source of privacy regulation. They always have an action against Facebook, basically, and a few others. And they say that their role is that they're a norm entrepreneur. It's not the police. Their goal is to take action. Their goal is not to take action against every violator of the rules, but to encourage every actor to improve their practices in reference to a relatively small number of actions. But some commentators have argued that this system, without modifications, encourages capture and laxity. And others suggest that the penalties carried by enforcement are simply too small. Like the end of a multi-year action against Facebook will be maybe, it will start with a number of maybe a couple $2 billion, but then it goes on. The question of whether or not they'll collect goes on and on and on. So are the penalties too small? Does it take too long to get them? And the FTC itself admits it needs more resources to adequately regulate privacy. And only a certain amount of resources is going to be accorded to regulation, public regulation, especially in the United States. The more fundamental problem, however, is when you're talking about a pervasive issue like unfair and deceptive privacy invasions by companies, or even children's privacy and health privacy. It's hard to imagine one agency being able to address all those violations. And maybe you need something more than just a norm entrepreneur. For deterrence, you might need someone worried that in any given instance of violating the law, someone who's there might notice and might hold you accountable. Accountability is just much more likely in a hybrid regime. So I'm going to skip down to discussing 3 federal privacy acts that actually have a hybrid enforcement regime. So hybrid enforcement regimes already exist in privacy law, and they've proven more effective than regimes that only use public enforcement. Regimes that use private enforcement alone also have limitations. Chief among them, I'm going to just spend less time discussing it, but there are limits to private enforcement coming from various limitations that American courts have put on the ability of individuals to bring claims, like standing, finding harm, etc. So it's advantageous to both have a public way to bring claims and a private way to bring claims, because coming from the private angle, you have to worry about standing, but you don't have to worry about that from the public avenue. From the public avenue, you have to worry about blanketing and getting accountability from every possible actor. and agency capture. You don't have to worry about that with private enforcement. So they are complementary to one another because public enforcement has advantages that private enforcement doesn't have, and private enforcement has advantages that public enforcement doesn't have. The three most important examples of federal privacy regimes that have hybrid enforcement are the Telephone Consumer Protection Act, the Fair Credit Reporting Act, and the Driver Privacy Protection Act. So these acts were directed at using private parties as an adjunct to or substitute for private enforcement. So they were constructed with the awareness that just recovering actual personal damages isn't going to be a sufficient incentive to bring suit. So they layer on a couple of benefits for people who bring private suit, right? Because you only get the benefits of private enforcement as a supplement to public enforcement when you actually have people bringing private suits. So these three statutes are together provide a sort of how-to in terms of not just creating a private right of action, but how to craft it in a way that it actually makes a difference. So the main thing that you might want to learn to realize about these statutes is that they have been successful in achieving concrete outcomes. The main privacy invasive outcome that was trying to be avoided by the Telephone Consumer Protection Act is to limit abusive telemarketing practices, and they did that. FCRA, which is the Fair Credit Reporting Act, they were trying to prevent abusive uses of consumer credit files. Those have been limited as a result of FCRA. And the Driver Privacy Protection Act has effectively eliminated the use of driver's records as a source of sensitive information. So they worked, but why? And what did they do correctly? And how can they complement public? How do the private rights of action complement public enforcement? So these laws, this group of law, TCPA, FCRA, and DPPA, they all protect individuals from privacy invasions that made each individual instance be relatively small, but the law reflects Congress's judgment that these invasions should not occur. So by having a private right of action, it more strongly deters these behaviors. And public actors, by contrast, can act where small stakes and long odds may make individual actions less likely. Public actors are well suited for addressing collective action problems because class actions with small claims are increasingly unlikely to pass muster. And agencies can provide guidance and administer bright line rules, such as the TCPA's Do Not Call registry. So that is how they complement each other. So in FCRA, which is the credit one, there's a threat of punitive damages. And in all of these, if the plaintiff wins, they have the opportunity to get attorney's fees from the losing defendant. And really, as one court put it, in FCRA, the primary factor in deterring erroneous reporting is the private right of action. Because even though there isn't a large number of plaintiffs bringing these private right of actions, private litigants are more likely to collect damages than a regulatory agent, which may make the threat of a private suit more of a deterrent. While it's uncertain and potentially expensive to pursue a privacy claim, a small subject of dogged sticklers and their lawyers may decide to do so. So this has an outsized deterrent effect, which complements the more broad-based guidance that's given by a regulatory agency. So as the sort of framing of the FTC's role, it's like we're a norm entrepreneur, we're not police. Well, agencies continue to be norm entrepreneurs. But if you really want to prevent bad behavior, you also need a police force. Even if they're not always acting, just knowing they're there deters behavior more than if you just had someone saying what the norms were and punishing, cherry picking a few cases to punish. That's the kind of that's sort of the argument there. That effectively private regulation supports public regulation by providing an additional source of additional regulators. So it's less likely that individuals will think that it'll be less likely that potential wrong actors think that they will get away with it. So I'm going to take it a step further as well. So private rights of action can reveal information about corporate conduct that would otherwise be hidden. So private rights of action allow for evaluation of the private sphere, which is spaces to which the state lacks direct access. So this is kind of similar to employment law, insofar as the state's not even going to be able to know if a wrongful employment practice happens at a private meeting, at a private company. Similarly, a lot of practices that are done that are privacy invasive are deeply ensconced inside the private sphere. So through things like the discovery process, where plaintiffs who have sort of an inkling that something's wrong can sue, and there are sort of limitations on discovery, but the threat of discovery, right? And this is why private rights of action are so important. It's not necessarily prevailing on a private rights of action. It's not necessarily prevailing on discovery requests. It's actually the threat that ends up shaping behavior. So private individuals who know about practices can directly sue, and that process of litigation can bring information out of the private sphere in an important way. So what I've been focusing on so far are the pragmatic benefits that come from enforcement with private rights of action. And I've outlined from that perspective that the main thing that a private right of action can do is deter bad actors because of the threat of more regulators. So this is why ultimately I'm in favor of, I'm okay with more limited private rights of action. So instead of, let's say, being able to sue under all aspects of the bill, you would be able to just sue for a right to explanation or a right to deletion or something like that, because that does create it begins to create the accountability and the threat of more enforcers and the bringing out of information out of the public sphere. All those functions are possible with even a limited private right of action. So once we understand what the exact nature of the pragmatic benefit of the private right of action is, that's a standard by which we can look to see, is this private right of action too cramped or is it not? So I'm going to get a little bit into the dignitary argument here, and I also want to at least talk about non-consensual pornography and breach of non-consensual pornography and information security as an application of this. Privacy has its roots in sort of the reason why we protect it is it's a right to a sort of inviolate personality. It's consideration of a personal interest. And private rights of action accord individuals the power to enforce their own rights, and it affirms their dignitary status as citizens. So how do they do that? This is kind of civil recourse theory, basically. So private rights of actions uniquely speak to the dignity of the citizen by putting the power to contest wrongs in her hands and allowing the individual to construct claims as entitlements. So private enforcement is particularly important for citizen engagement and identity. And when you are in a courtroom, you kind of are standing on the same as peers, as equals before the state, and having this be evaluated. This sort of goes back to its origins, the sole sorts of rights for English citizens. Individuals attach greater value to rights they possess versus interest provided at the sovereign's leisure. Given that personhood and citizen dignity is particularly important in, the general argument for that, the ability to confront is a vindication of individual dignity applies to overall any type of private litigant, but we don't necessarily have or even want private rights of action for everything. But given the particularly strong relationship between personhood and dignity and equal citizen status and privacy, because not only is privacy about personality, it's also about the ability to write, to read, and develop ideas in communication and things like that, as we've seen with Cambridge Analytica and the like. So given the particularly strong relationship between privacy and dignity, and privacy and the sort of ability of individuals to participate in a liberal democracy, the form of the right to be enforced should have some relationship to that. So and I think that that's kind of best illustrated with examples, right? So I wanted to talk through non-consensual pornography and information insecurity, data insecurity, because they kind of reflect two poles in justifying private rights of action and privacy law. So both deterrence and dignitary concerns are reasons to have a private right of action in privacy law. They sometimes are in tension, but they are both independent reasons why we might want a private right of action. But for some types of problems, one justification is more important than the other, and that might influence how exactly we construct the private rights of action in each given problem. So non-consensual pornography is an example of an area of privacy where, and by the way, there are other areas like, let's say, digital market manipulation, where there isn't a clear, one isn't clearly more important than the other, right? So these two are kind of brought up as sort of more examples where these two factors, one is more important than the other. So to the extent to which they're in tension, you might choose dignitary goals over deterrence goals. But in other areas like digital market manipulation, for example, you might be less likely, the trade-off might not be so easy. So briefly, non-consensual pornography, this is the distribution of pornographic images of a person without their approval. This humiliates and harms the victim. This is becoming more and more possible as a result of changes in technology. There are no federal statutes in the United States on this topic, but most states have criminalized it, and many have also created civil private rights of action. So many states do have hybrid regimes of the type I'm talking about for non-consensual pornography. And actually, the Uniform Law Commission in 2018 approved a standard law that states can copy that outlines a private right of action and types of remedies for that. So there's a strong momentum for private rights of that. So it's already been criminalized virtually everywhere, but now we're moving towards a private right of action in non-consensual pornography. This is one of the greatest expansions of the privacy interest in recent years. This is sort of a model that I think that other areas of privacy can look to, because they've been able to get statutes passed and ultimately, after a little while, a private right of action as well. So having a private right of action, both you can see both of these justifications as to why, like, this more strongly deters action because knowing that someone can sue, and also makes you less likely to engage in this kind of behavior. So deterrence is a factor, but dignitary concerns are even stronger, right? You kind of flinch at the idea that, you know, if someone has been a victim of non-consensual pornography, the question of whether or not they get any type of relief comes down to the question of whether or not a regulator thinks it's worth the time to pursue this individual claim. It seems like, no, if it's wrong, it's wrong, and if the regulator doesn't have the resources, or maybe not the inclination, depending on who the executive is, the individual should still have the ability to vindicate this right, because the allegation is so severe, the wrong is so personal, that it shouldn't come down to whether or not a regulator has the time or has the inclination or agrees with availability of this right. So this is a pretty strong example of given the dignitary nature of a privacy right, it seems that a private right of action should follow, because if the state is going to accord someone the right to be free from this form of invasion of privacy, you should also be giving the individual the tools to force the state to allow them to be free of that. So so non-consensual pornography illustrates this sort of strong, how the dignitary feature of the privacy right points towards the availability of a private right of action. It also, as you can see, like, we also have it to have further deterrence, but it shows how dignity can be important. So data insecurity. Data is another area which affects many people. So the interconnectedness of devices has made people much more vulnerable to theft and misappropriation, and information is getting stolen, which includes highly sensitive information and the like. Protecting data involves trade-offs, and current law doesn't really give, at least in the United States, companies many incentives to protect individual data. And there are many publicized hacks of large consumer databases, which causes people's data to be exposed. While we do have data breach laws, which provide public law enforcement with mechanisms intended to protect consumers' personal information, and to be transparent about it, this hasn't sufficiently deterred it. So providing a second set of regulators to come after companies who have invaded people's privacy in this way by negligently making this information available could increase the deterrence factor here, because we already have a slate of public enforcers on this area, and the outcome is simply not proven enough. There's reputational harm for data insecurity, but the evidence is mixed as to whether pure reputational harm influences the behavior of firms. You ultimately have to make them pay. So this is an example of an area of privacy law where the main thing you'd be doing with a private right of action would be supporting public enforcement by providing an alternate avenue of enforcement. This would ultimately mean changing the nature of data breach law too, to include some form of damages. So much like the TCPA and FICRA and the like, where there is a construction of the right so that, hey, look, losing party pays damages. There's punitive damages of, let's say, $200 a case. So by putting the finger on the scale to encourage more private enforcement and increasing the likelihood that these cases will be brought in, we can more effectively deter bad actions than we have in the private sphere. Now, the dignitary feature here, while not as screamingly obvious as in data, sort of non-consensual pornography, it's still present, right? It's still present. And this is because you see this in digital market manipulation. A lot of these wrongful data privacy practices, while it's not sort of as intense as sharing a non-consensual nude image. It really is ultimately treating a person as if there's somebody to whom no regard is needed, right? Well, whether I pay attention to whether someone's data is secure or not, it doesn't matter. I don't know them anything, right? And especially if you're talking about a company that you were in contract with that has presented itself as someone who is looking after your interests, like let's say every single company nowadays is like, oh, we care about your privacy, this and that. These what they're doing is they're treating you as if they can say one thing and do another. I mean, it's a form of disrespect, right? It's not the type of disrespect that maybe keeps you up at night because you're so uncomfortable, like non-consensual pornography, which is why I would say the deterrence is dominant here, but it still is a dignitary violation, because in having no regard for the individual and no respect for taking care of their data, they really are saying that you're nothing and there's nothing you can do about how the fact that I'm putting you at risk. And by giving individuals a public right of action, you're saying they don't have the right to treat you like you're nothing. You have the option of suing them if they do something to you. And that, again, goes back to this dignitary idea that when there's a private right of action, people stand as equals. The mouse can sue the lion, and so forth. So the dignitary aspect is present even when we're talking about instances which the deterrence factor is more preeminent, but they're both there. So ultimately, my point was that deterrence and dignity both counsel towards providing a private right of action in privacy law.